Hi everyone, sorry I'm a little late. I don't know if you saw in my other post, I said that my internet decided to go down. Rather inconveniently, of course. My timing is great as always. Hi, just want to wait a few minutes. For those of you who have already joined me, if you'll notice in the actual post itself, I did something a little bit different this time. I've added a link to my notes for the video. You'll have to apologize if they're a little all over the place, but I am actually I'm actually going to be reading more than I normally would because I'm going to be talking about a specific case and a lot of citations that are inside the petition for post-conviction relief. You know, that one that was filed all the way back in June 2017, which is actually what's under appeal. Seems like forever ago, but that is still what we're actually, waiting to be reviewed right now. This is not exactly new info, no. This is me discussing things that have already been filed and a little bit of a preview of some of the arguments that Kathleen is going to be making in her brief when it's filed. This is one of those things that I've kind of had in the back of my head for a long time, pretty much ever since that petition for post-conviction relief was filed. And I was just waiting until closer to the time of when the brief was going to be filed to start discussing some of these specific cases and how they apply to Steve's case and what kind of effect they can have on the appeal or the decision by the Court of Appeals. Not too many people are here yet, so I'm just going to still kind of just wait for a few minutes. Not terribly exciting for all of you to sit here and just watch me sitting here, I know, but I don't want to have to repeat myself a bunch, so. Sorry. Don't want to just sit here and have you staring at me. Okay. I know I'm starting this later than I planned. I actually had to take my daughter to the airport because she's headed back to Syracuse today to finish her final semester of grad school. So that's why I couldn't start it any earlier. I had to do that first, and then I was trying to finish my notes. I didn't think it would take very long, and I kept adding things, and then my internet went down, and so it's been kind of a comedy of errors. But so I know that it's probably too late for a lot of people to join, but hopefully some of you are still around. I hate that I have to scroll for these comments because that's kind of annoying. I keep thinking that nobody's saying anything. Make faces at you. I kind of do that anyway. I never realized how many weird faces I make when I'm talking until I started doing these videos. Hi, Ray, all the way from Ireland. I'm so jealous. That's one place I'd really like to visit one day. Okay, well, I'm going to start because I'm not sure, but I'm sure people will be joining us. So what I really wanted to talk about today was a few things about the appeal. I talked about this in my group many times, but one of the issues that I don't think a lot of people completely understand is the issue of procedural bar. So I want to talk about that, what it means and how it can be overcome. And I want to specifically discuss after that some of the claims of ineffective assistance of counsel. And specifically, I'm going to be talking about the case, State of Wisconsin versus Thiel, which actually has a few components to it that I think are really important to Steve's case. And then I'm going to talk about that case and then hopefully compare to some of the similarities in Steve's case. And then you guys can ask questions if you have any about anything else. Okay, so, oh, there's a few more that have joined us. Okay. So one thing to know about this appeal, well, the first thing is that I know that it seems like a lot of people are confused, or not confused, but they think that there have been a lot more decisions in this case than there actually have been. That's because, I probably mentioned this in my last video, but that's because this case has actually been in front of the Court of Appeals for over a year. The brief that is due on February 1st was actually originally due last January. And the Court of Appeals has never actually heard any of the case yet. The case has not been presented to them yet. It's been sitting in the court for a year, but until the briefing starts, they actually haven't heard anything about the case. So it seems like everything seems to always be going the wrong direction, but honestly, nothing has really been decided by the Court of Appeals at this point, other than the denial of the motion to remand. So, okay. This case is going, and I'm going to apologize again right now because I'm going to be reading a lot. This case is going to be won or lost on, no, Joy, can you hear me now? Okay. I know you said I may not have been talking, I don't know. This case is going to be won or lost on that dog, I swear, one major component, and that is the issue of procedural bar. Now, for those who don't know what procedural bar means, and this was, Kathleen did discuss this in the petition, is that when a verdict is reached in a trial, actually once sentencing has happened, one of the first things that counsel is going to do, defense counsel is going to do, is that they're going to tell the court of their intention to pursue post-conviction relief. And that is the attorney's first opportunity to try to mitigate some of the issues that happened during the trial. That's the first time they get to present any type of basically appealable claims, okay? And that is still held in the trial court. Okay, that's, again, just considered like a continuation of the trial where they can raise claims like ineffective assistance of counsel and any other claims that they felt were unfair during the trial, Brady violations, whatever. And if they lose during that post-conviction process, then the next step is to file what's known as a direct appeal. Okay, a direct appeal is attacking the verdict. Okay, it's attacking potential errors of law, trial errors, technical errors, and attacking the verdict itself. You're basically saying, like, okay, that he is actually not guilty and he should have been found not guilty for all of these reasons. If you lose your direct appeal, okay, then that is when you have the opportunity to file something like what has been done in this case, which was the 97406 petition for post-conviction relief, which is technically not even an appeal. It's considered a collateral attack. The same is true of a federal petition for a writ of habeas corpus. That's another type of collateral attack. And what collateral review means, that it's different from a direct appeal because you're not attacking the verdict itself. You're attacking issues collateral to the verdict. And in a 97406, this specifically means constitutional issues or jurisdictional issues. Okay. But one of the rules is that you cannot present anything that has already been fully litigated by the courts. So if it was an issue that was brought up on post-conviction or in the direct appeal, that means that you cannot bring it up again in your new petition for post-conviction relief. That seems pretty straightforward because they already told you no, so you shouldn't be able to bring it up again. But when you're talking about procedural bar, what that means is that not only were you supposed to bring up any type of trial errors or anything like that during your direct appeal, but you were supposed to bring up anything, anything that would have been a substantive claim of error during a trial, whether it be a constitutional violation or not. If it's something that you did know or should have known through exercising due diligence, then it should have been brought up on direct appeal. If you didn't bring it up, then the courts consider that issue waived. That they're basically saying, well, clearly this isn't an issue, or you didn't think this was an issue, so you should have brought it up then, and if you didn't, well, too bad. It's too late now. Okay. So when Steve filed his pro se 97406 petition, that was pretty much his final chance to bring up any of these claims that he wanted to present as a constitutional violation of his conviction. When he didn't bring them up, again, the court says, well, then you've waived your opportunity to present those issues. And that is a huge bar to filing another 97406 petition. And this is why Judge Suckowitz did not even consider about 70% of the petition, because she said that he was procedurally barred from presenting them because he didn't bring them up in his previous pro se petition, and therefore those issues are waived. Okay. And that is really the hurdle that has to be overcome here. If the Court of Appeals agrees with the circuit court judge and says that, yeah, you needed to bring these up already, you just can't bring them up now, you waive those issues, then it's going to be really hard to win this case. But there are some exceptions to that rule. And I'll get into both of those in a minute, but Kathleen did satisfy those exceptions. Now, whether her arguments are good enough to win or not, I don't know. I mean, they should be, but since the court didn't even evaluate them, it's hard to say. The court essentially said she didn't even try to argue a reason as to why these claims weren't brought up before, when she very clearly did. Now, in my group, and it's included in the video notes now, I had put together a graphic of essentially my very bare bones reasoning as to why I feel like the Court of Appeals should reverse this decision. And that is because the judge made some, in my opinion, some very clear errors when it comes to the law. Now, I'm going to talk more about, this is great, I just realized my printer kind of printed funny too, so I'm missing entire sentences on my notes, so that's great. Things are just going well for me today. I'm not going to be able to read some of this. Oh my goodness, this is just awesome. Okay. Okay, that's going to go great. When you're talking about the standard of review that the Court of Appeals uses, I'm going to talk about this again later, which is why now I'm trying to find it again. I mentioned it later. When you're talking about discretionary decisions, and that is what a lot of what Judge Suckowitz's decision is, her opinion is, they're discretionary decisions. When you're talking about that, I cannot believe I can't read half of this now. I should have looked at it before I did this. Okay, bear with me a minute, because I'm just already confused now. Okay, when you're talking about discretionary decisions, the circuit court's findings are given a great amount of deference, okay, because they're the trier of fact, and the Court of Appeals says, well, since you're the court that actually heard the evidence, heard the witnesses, you have a better understanding of how credible everything was, and you can make a better decision with regards to the facts of the case. Now, the higher court, though, still can reverse discretionary decisions when the facts that the circuit court judge used, or the reasoning they use, when the facts don't support the court's decision, or the court applies the wrong legal standard. And that is pretty much key to where her decision is just plain wrong. I mean, it's just wrong. There's really no other way to put it. You know what? Hold on one second. Ashley, can you run out to the garage and get can you go get my iPad for me? Because I can't read my notes. I'm really sorry. I am just the peak of professionalism tonight. Okay, so if the circuit court applies the wrong legal standard, it doesn't matter whether they were the ones that heard the facts of the case, then the Court of Appeals can overturn the decision because they are the ones that review matters of law. I'll get into that a little bit more later. Okay, so I just want to go over a little bit about what I had put in this graphic. In Judge Suckowitz's decision, she says, in his motion, the defendant asserts that his post-conviction counsel was ineffective for failing to raise these issues in prior motions submitted to the court. A circuit court is not authorized by statute to resolve claims of ineffective assistance of appellate counsel, and they cite State versus Knight. In this matter, if the defendant wishes to pursue the claims regarding his appellate counsel, the defense may file a Knight motion with the Court of Appeals. Okay. Now, in the state of Wisconsin, a Knight motion is also, that's also usually what they consider a petition, a state petition for a writ of habeas corpus. But they just call it a Knight petition since it was ruled on in the case State versus Knight. Now, her description of the law is correct. Okay, when you file a claim of ineffective assistance of counsel against appellate counsel, it has to be filed in the Court of Appeals. But when you file a claim of ineffective assistance of counsel of trial counsel or post-conviction counsel, it has to be filed in the circuit court, which is what Kathleen did. And she stated very clearly that even though Steve had the same representation in both his post-conviction proceedings and his appellate proceedings, she was filing these claims against them in their post-conviction capacity, not in their appellate capacity. That means she filed it in the correct court and the judge is wrong. If she filed these claims against them and their actions, the representation during his appeal, his direct appeal, then the judge would be correct, but she didn't. So that, I don't know how you look at that in any way other than as an error in law. Because the judge is saying, I'm not considering this because you didn't file them in the correct court. Well, yeah, she did. Sorry, judge, you're dumb. Okay, so I said that Judge S makes a clear manifest error of law when she says that the appellate IAC claim raised to be filed in the Court of Appeals under a Knight petition. This would be true if she'd filed claims against appellate counsel, but she didn't. She filed it against post-conviction counsel. So right there, that's enough to reverse that part of her decision. She should have to, if she's not saying that these IAC claims fall under procedural bar, but they're just filed in the wrong court, well, then they should have to be reviewed. So if anything, the Court of Appeals should reverse just on that decision alone. The other error is that she says, and again, I'll read from her decision, the defendant also asserts that his prior pro se motion filed under the statute should not preclude this motion being heard. The defendant's pro se motion does recognize significant legal issues which the court has previously ruled on. There is no argument or showing of a sufficient reason as to why these issues could not have been raised in prior motions. Without such sufficient reason, these arguments are precluded from any subsequent motion. Okay, this is the important part. She says there is no argument or showing of a sufficient reason as to why these issues could not have been raised in a prior motion. Again, she's flat out wrong. Kathleen cited State versus Escalona. No, I don't want to say the whole thing, but she says that Kathleen made no argument when she did. You know, she said the reasons why, oh, here, I think I wrote it down. I just said that KZ states that there are sufficient reasons why the claims weren't previously raised, and then she goes on to list several of them along with the applicable case law. So again, did the judge just fall asleep during that part of the petition? I don't know how she can say that she made no argument. Now, she didn't say that she made arguments and they weren't sufficient. She said she made no arguments, which is just factually untrue. Now, some of the arguments Kathleen made was that, that Steve did not have competent counsel, and that he now had competent counsel, that he did not have the legal acumen in order to properly raise some of these claims. The fact that his case file alone is too large for him to even be able to keep copies of his entire case file. The fact that he did not have the resources in order to obtain the experts and that he would need to obtain in order to make some of these claims. That was just a few of them. She made all these arguments. So if the judge wanted to properly dispose of that claim, she would have needed to address those specific reasons. So if she would have addressed them and then said, in her opinion, that they did not raise to sufficient reason, then she could have ruled against it. But that's not what she said. She said that she didn't make any arguments when she clearly did. So those are, like I said, those are just, it was a pretty short decision. And even in just that little part, she says two things that are complete errors in law. There, errors in fact and law, both. So when you're looking at, again, what the court said about when they can reverse a discretionary decision, the two of the reasons are, it says the facts do not support the court's decision. Well, the fact that she said there was no argument when there was. And then the court applies the wrong legal standard, citing, that the Knight standard and saying that she has to file in the appellate court when she actually didn't have to do that, is applying the wrong legal standard. So, that's just like this in the simplest terms of why the Court of Appeals should reverse just for that reason alone. Okay, so does anybody have questions about that part? How can a judge get away with that? Well, yeah, it's like Eric said. It's a discretionary decision. A judge can get away with saying whatever they want, but that's why we have appellate review, because it's a system of checks and balances. You have another court that is essentially, watching over this other court so that these types of errors don't get through. And so honestly, if they don't recognize those as errors, then I'll be baffled, because I don't know how I could put it much plainer than that. So before I move on, I just want to know if there's any questions about the procedural bar issue and my specific thoughts on those two parts of the decision. It's kind of funny when you think about the fact that this has been under appeal for a year and there's going to be a huge brief. And really, I think it boils down to those two issues right there. Oops, sorry. Well, yeah. Well, it says, will the KZ petition now be about her most recent decision? The brief is going to cover everything. The brief is going to cover everything that Kathleen has filed in support of Steve getting a new trial or getting his conviction overturned since she took over the case. Lori, clear as mud. Yeah, and that's one thing to me that is actually one of the clearest things in this case. I said it only took like 2 paragraphs to actually say what is just completely wrong with her decision. And then Maureen said, will KZ address to the judge that she was wrong? Yes, she actually already brought up these facts in the motion for reconsideration, and the judge ignored that too. So these are, I'm pretty sure these are things she brought up. And so she'll bring them up again in the brief. That's what I've said before, like when people are saying like what's going to be in the brief, they're going to be the arguments she already made in the motion to vacate and in the motions for reconsideration. She's just going to make stronger arguments and provide more case law and be a little bit more detailed in her arguments. My dog is killing me right now. Okay, so just give me a minute because I need to open up my iPad to my notes so that I can actually read the things that I wanted to say to you. Hi, Carol. Oh, gosh. Sorry. Again, things just aren't going my way today. They really aren't. I have to sign into my account apparently because I don't know why. And of course I typed it wrong. Sorry, bear with me. Hope everyone's having a good day. I swear there's going to be a time when I'm just not going to completely fail at these videos. Are you kidding me? Okay, so anyway, now I've got these all out of order too. Okay, just one more minute. 3. Let me see if there's a, so now when the ineffective claim gets pushed back down to AS, she gets to decide if it was ineffective. An ineffective judge making a decision on an ineffective claim makes sense, yeah. Sorry, Elizabeth, I feel your pain. Thanks, Caroline. I do. I feel like I just feel like I'm just a disaster at these things. And I was really hoping if I was prepared, I could do like better today, but you know, and then my dog's just gonna keep barking on top of it because, you know. Okay, now I actually have my notes now that I can read. I'm just gonna have to read them off my iPad. Okay, sorry. Okay, so, and that was actually the wrong thing. Dog is just killing me right now. Just ignore her. Okay, so what I wanted to get to after this, okay, is that I want to specifically talk about the case, State of Wisconsin versus Thiel. Okay, Kathleen cites this case a couple times in her petition, and it's actually a really good case as far as there being some very good similarities between some of the things that have happened in Steve's case and what happened in that case. And obviously, based on the Supreme Court's decision, could be a very good indicator of how they should rule in Steve's case, because some of the situations are very similar. And so it's one of the better citations. Thanks. If the judge decides not to listen to all arguments and declines all evidence, well, the judge has no choice. I mean, they have to listen to all arguments, even if she didn't yet, she's going to have to, or the Court of Appeals is just going to not deal with her anymore. They're just going to order the hearing themselves, and then Kathleen can get a new judge. But yes, I mean, the Court of Appeals is going to listen to all arguments. They have to. Okay, so in her petition, okay, Kathleen cites specifically some of the failures of the trial counsel during this case, things that would amount to, in her opinion, ineffective assistance of counsel. She says that trial defense counsel failed to properly investigate a variety of topics: Sergeant Colborn's dispatch call, timelines, voicemail deletions, items from Maribel Caves Park, suspected burial site, veracity of police reports, witness to the RAV4 planting on November 4th. Now remember, this was in her original petition, so other things have come up since then, which I'll also mention. But these are just some of the things that she's covering as far as ineffective assistance of counsel claims. Now, in State versus Thiel, the Wisconsin Supreme Court granted post-conviction relief after the defense attorney at trial failed to conduct a significant investigation. There, the defendant set forth precisely what would have been revealed had the defense attorney conducted an investigation consistent with the defendant's constitutional right to counsel. As in Thiel, relief is warranted. Thiel also supports Mr. Avery's position that relief is warranted because his trial defense attorneys were ineffective in failing to properly review the discovery prior to Mr. Avery's trial. In Thiel, the defendant's allegation that his trial attorney had not reviewed all of the discovery constituted an additional basis for the Supreme Court to grant relief. The same result is compelled here. And that is on page 119 of the original petition for post-conviction relief that Kathleen filed. She also cites Thiel in her petition when she discusses the applicable case law involving ineffective assistance of counsel. She references the court addressing the cumulative effect of deficient performance of counsel, and that's on page 44. Again, this is all in the notes because I know, like I said, I'm reading a lot, and you might just want to save the notes just so you can refresh your memory on some of this stuff. So there are two specific issues being argued that are relevant to Steve's case, and that is failure to investigate and failure to properly review pretrial discovery. And then also important is the fact that Thiel addressed the cumulative effect of IAC claims when it comes to evaluating the prejudice prong required under Strickland versus Washington. Okay, Strickland versus Washington is a 1984 case that established essentially the rules when it comes to ineffective assistance of counsel claims. Under Strickland, and I should say in the notes, I actually have links to all of these, all of this case law in case you want to read. I'm only touching on a few things, so if you want to read the entire opinion, I have links to them. Under Strickland versus Washington, the Supreme Court said that the defendant must show that counsel's representation fell below an objective standard of reasonableness, and a defendant generally must show that counsel's deficient performance prejudiced his defense. Now, when they say that it prejudiced his defense, what they're saying is that it essentially prejudiced the jury against him. Okay, it made them look more unfavorable upon him because of the deficient performance of counsel. I'm not going to comment on that, Eric. Was Thiel in post-conviction or on direct appeal? Well, he filed direct appeal. I think I'm going to cover that, actually. Let me get to that in a second. Okay, so when they say that, that the defendant must show that counsel's deficient performance prejudices defense, they also went on to clarify, the defendant is not required to show that counsel's deficient conduct more likely than not altered the outcome of the case. Rather, the question on review is whether there is a reasonable probability that a jury viewing the evidence untainted by counsel's errors would have had a reasonable doubt respecting guilt. And then they define reasonable probability under this standard as probability sufficient to undermine confidence in the outcome. Okay, so that is the standard that you have to meet when applying Strickland. And usually the hardest one to meet is the prejudice prong. Okay, it's trying to show that their deficiency was great enough to undermine confidence in the verdict. Okay, so now I'm going to go specifically into State versus Thiel. Let me see if there's anything else right now. Are you guys with me so far? I like that my videos are usually more conversational, and this is very technical, and I do apologize. It probably makes it a little more boring, so sorry. Okay, so in Thiel, the Wisconsin Supreme Court said that Thiel's trial counsel often performed effectively. Okay, so they're not saying they were terrible. They're saying that they actually performed okay in most cases. However, or I guess there was only one trial counsel that was under, that this claim was, he had multiple attorneys. This claim was against one specific attorney. It said, however, he failed to use a great deal of available evidence to impeach the state's chief witness because of inadequate trial preparation. We conclude that counsel's performance was deficient in several respects and that the cumulative effect of the deficiencies prejudiced Thiel's defense to an extent that it undermines our confidence in the outcome of the trial. So, a little background on the case. Okay, Dr. James Thiel was a psychiatrist, and he was convicted of 7 counts of sexual exploitation by a therapist. Okay, it's a weird case, kind of, but aren't they all? This is a 2003 Supreme Court case, by the way. The victim was a former patient, and she was identified only as Joanne P. Her last name was never given. The key witnesses in the trial were the victim, a friend of hers named Brian Ecorn, who she supposedly confided in about this inappropriate relationship with Dr. Thiel. And he also just happened to be an assistant district attorney in a neighboring county. And a Dr. Metzler, who was the psychiatrist that she saw after she stopped seeing Dr. Thiel. I've provided a link to State versus Thiel because I only want to go over a few of the key points, things that are probably going to be relevant to Steve's case as well, because there were a lot of issues, but these are some of the key points that they brought up. Some of these don't even matter. I'm just putting them out there so you can understand the case. The investigation actually started after Joanne brought a semen sample into the La Crosse Police Department as quote unquote proof that she had a sexual relationship with Thiel. The state tested the semen and determined that it actually didn't belong to Dr. Thiel. It was just some other random dude's semen. But for whatever reason, they did not stop there because they had already brought the charges prior to the test results coming back. Because really, there really shouldn't have even been a case at that point. Because now she's a pretty much established liar. Thiel exercised his constitutional right to a speedy trial, even though one of his attorneys told him that they could use more time to prepare. And I don't think I put it in my notes later, but there is a reason why I added that. Hopefully I'll remember. If I don't, maybe somebody remind me, if you care. Dr. Metzler testified that a psychiatrist should document any contact with patients that occur outside of an appointment. Dr. Metzler's testimony, the court indicated, during his testimony, the court indicated that Dr. Metzler should confine his testimony to standards that physicians might employ rather than his own personal practice. Now, this was a situation where Thiel's trial counsel actually didn't object themselves. The judge intervened. Like basically the judge sitting there, I'm like, why aren't you objecting, idiots? You know, so he stopped himself and he was like, look, is this something that's actually a standard practice, or is this just what your opinion is of how it should be done? And he stated it was his personal opinion. And so the judge was like, yeah, that doesn't fly here. I don't care what your personal opinion is. You know, we're talking about what is standard practice. Just because he didn't do what you did doesn't mean that he was wrong in any way. Trial counsel only objected once to Metzler's testimony. And even though the court basically said his testimony was inadmissible, trial counsel never moved to strike any of it. You know, so it just stayed in there. So it was something that could have been considered by the jury when it never should have been. And then Thiel contended that Joanne's accusations were in retaliation over his refusal to assist her in obtaining disability benefits. Okay, so that's just important to know as far as the case goes. Not really because of Steve's case. After his conviction, Dr. Thiel retained new counsel and filed a motion for a new trial on the basis that his trial counsel was ineffective. He alleged numerous deficiencies, including that his counsel failed to file a motion that may have permitted the introduction of Joanne's medical history, and that trial counsel failed to adequately investigate the underlying case against Thiel, and that trial counsel performed inadequately during trial. The circuit court conducted a Machner hearing, so this was part of his post-conviction process. Okay, his original post-conviction process. They conducted a Machner hearing on the issues. Okay, so a Machner hearing is an evidentiary hearing that is specific to IAC claims. So in Steve's case, we just refer to an evidentiary hearing because there are multiple claims being made. If Steve was only referring to IAC claims, then we'd be referring to it as a Machner hearing. And that's based on another case. I actually have that listed later on too. Okay, so the circuit court, now this is the court that heard the post-conviction proceeding. The circuit court found that counsel's actions were deficient in 4 primary areas. First, counsel did, and I have these first 2 highlighted because these are the important ones. First, counsel did not adequately read and review the discovery materials that had been provided by the prosecution, and the overlooked materials contained potentially important information for Thiel's defense. That should already sound kind of familiar. Second, counsel did not conduct any significant independent investigation into the underlying facts of the case or the credibility of the prosecution's witnesses. Again, should ring a bell. And then the other two in this case was that they said that counsel failed to file a motion that would have allowed the defense to obtain personal medical history of the victim, and that they didn't strike any of Dr. Metzler's testimony. Based on all that, the court concluded that these deficiencies unconstitutionally prejudiced Thiel. So they granted his request for, I believe in this case, they granted his request for a hearing because he was denied a hearing. So I think that's what they did here. I don't think they overturned anything yet. They just granted the Mockner hearing. The Wisconsin Court of Appeals found that while Thiel's counsel may have been deficient in a few instances, any deficient performance was not prejudice to Thiel's defense, and the court reversed the circuit court's decision. Okay, so they said, well, yeah, their representation wasn't the best, but they didn't think any of it was serious enough that it would have undermined confidence in the outcome. I'm waiting for questions. To my understanding, even Strang and Buting support KZ submitting ineffective assistance of trial counsel. Yes, so far, I mean, they've filed affidavits, so that helps. And it's really hard to win an AC claim if you can't get the attorneys on the stand to at least explain why they did or didn't do certain things. But every attorney knows that at some point that they're going to be looking, that an appellate attorney is going to be looking for IAC claims. They're not usually too offended by it. It's pretty standard practice. Arguing an IAC claim with procedural bar issues with case law that was decided on direct appeal with no procedural bar is going to be kind of tough. Not really, because they're two separate issues. That doesn't really matter. They're two completely separate issues. So it doesn't matter that whether this case had a procedural bar issue attached to it or not. Great layman translation. Okay, Eric. Okay, yes, definitely parallels. Yes, already, and we haven't even scratched the surface yet. There's more. Okay, so in the Wisconsin Court of Appeals opinion, there actually was a dissenting judge, meaning the smart judge in this case. The dissenting judge wrote, "Was this a fair trial? When a trial answers that question no, and there are facts and evidence to support that answer, appellate courts should only, in rare case, reverse that answer." And that's essentially what he's saying the Court of Appeals did here. They're saying that it wasn't a fair trial, and for some reason, they're still reversing the decision. Okay, so now I'm going to go back to standard review. And I talked about this in the beginning when I was stumbling over my notes about the different standards of review, because this is something that's come up plenty of times already, okay? There are different standards of review that the Court of Appeals uses when deciding a case, okay? And the two that are applicable to ineffective assistance of counsel claims are erroneous exercise of discretion and de novo review, okay? Questions of fact are reviewed under the erroneous exercise of discretion standard. Again, I've explained this before. Since the trial court is the fact-finding court, they do give a lot of deference to that court. They take a lot of consideration or give a lot of consideration to their decision on the facts of the case. Like I said before, I'll say it again because it's important. The higher court will find that discretion has been exercised erroneously when the trial court fails to exercise its discretion. The facts do not support the court's decision, or the court applies the wrong legal standard. Questions of law are reviewed de novo. And de novo was a term that was thrown around a lot, and a lot of people were confused about it, what it meant, and I think a lot of people thought it meant what it didn't mean. They said it's just a standard review, okay? The higher court, de novo review means that the higher court independently reviews the case with no deference whatsoever to the lower court's opinion. This is why they review everything, because they're basically acting like her decision does not apply at all, or does not carry any weight at all when it comes to questions of law. And the reason for this is because circuit court judges are going to make more errors of law because they don't deal with it as often. They don't, and they also aren't precedential. So all the Court of Appeals does is review law, create case law, establish case law, better way to put it. So they are the experts in law. Okay, so that's why they have basically ultimate authority in deciding whether the circuit court followed the law or not. Okay, and now, interesting enough, and I didn't put this in my notes, but Thiel actually tried to argue, since in this case the circuit court was actually on his side, he tried to argue, well, in this case, there should be some deference given to the circuit court's decision when it came to matters of law, you know, for whatever reason. And he actually used the reason why, the same reasoning as to why they are given deference when it comes to questions of fact. And it was that, well, they had a better understanding of it, they got to witness all of this, blah, blah, blah. And the Court of Appeals was like, no. This is the way it is, the way it's always going to be. But they did say that when the circuit court includes their reasoning as to why they ruled the way they did with regard to the law, they do obviously look at that and they will take it into consideration. But ultimately, they are the only decision makers when it comes to whether the law was applied correctly in a case. And IAC claims are considered mixed questions of law and fact, and that's why it's reviewed under both standards. The facts of the case, or facts of an IAC claim, are basically the what happened. Okay, what did they do and what didn't they do that is being alleged as deficient? And all of that can be supported by the record of the case. Okay, so any facts should be supported by the record of the case. You can't just make things up. Okay, you can't make up things that didn't actually happen. So that's why they give a lot of deference to that, because it's very easy for the Court of Appeals to see whether or not the court is just wrong in their factual description of what happened. Questions of law, obviously, are Strickland versus Washington. Did they apply Strickland correctly? That's basically what the matter of law is, and that is fully for the Court of Appeals or the higher court to decide. In this case, it's actually the Court of Appeals said, you know, they actually overruled the circuit court, so it went to the Supreme Court. So the Supreme Court is reviewing the Court of Appeals decision when it comes. Well, actually, they're not reviewing the Court of Appeals when it came to a question of law. They're reviewing it de novo. So it's like the Court of Appeals ruling didn't exist. It's like the circuit court's ruling didn't exist. They're looking at it completely with fresh eyes. Off topic, can you discuss any jury issues in Steve Brennan's trials? Is this because of the question earlier? I'll get to it at the end, Dawn, remind me, okay, when I'm at the end, because you know how easily I totally I go off on tangents and I lose my train of thought. Okay, so it said that the circuit court's findings of fact included specific instances of how trial counsel failed to adequately examine discovery materials and of their failure to investigate. And then, so some examples they listed under failure to investigate are as follows. Counsel conducted only perfunctory interviews with law enforcement and Ekern. That was the friend, that was the witness. Counsel made no effort to speak with the complainant, so they made no effort to speak to the victim. Counsel made no effort to interview the husband of the victim, who was listed as a witness for the defense. And why that was important is because if they would have spoken to him, they would have realized that she had lied about something she said. Because she said that her husband knew about this when he really didn't. Counsel did not check the Consolidated Court Automation Program, otherwise known as CCAP, or make any open records requests on the background of any persons who were to testify. This is, again, similar to Steve's case, because if you will remember back to the ridiculous Denny motion that trial counsel submitted, they didn't do any deep background on any of this. They basically went by what Steve told them were things that had happened in these guys' past. Technically, I think they may have consulted CCAP on some of these things, but again, they just did the most like rudimentary, they took the most rudimentary looks at these people. They didn't do anything that could actually establish motive or, you know, opportunity or anything. They just basically said they have a shady past. And then they also said that, or the circuit court also said counsel made, this one is really good. This one, I don't want even to tell you what the parallel is. Counsel made no attempt to obtain telephone records between the complainant and Ekern, between the victim and her friend, to establish when she had told him of this affair that she was alleging took place. Okay. So here I just put similarities to the IAC claims raised by Kathleen. She says that trial defense counsel tried to combat the state's 14 experts merely by using cross-examination without their own experts in blood spatter, DNA, forensic pathology, ballistics, and forensic fire analysis. Okay, so she's saying that they were deficient in providing experts to try to basically counteract the state's experts. Interestingly enough, this is not a citation in the petition for post-conviction relief because it is a very recent case. It just happened over this last summer, August of 2018. And in the case State versus Render, which I really hope that Kathleen cites in the brief. This should be an example of a new citation that wasn't in the previous filing because it's really good, in my opinion, when it comes to this topic in particular. And so I have a little side note that this is not with regards to Thiel, but in the case State versus Render, the court did reverse a circuit judge's decision denying a post-conviction motion based on newly discovered evidence, which is what we're looking at here, when that new evidence was the testimony of an expert that contradicted what the state's experts said at trial. In that case, the court ruled that since the new expert testimony was relevant and material to the case, the circuit court must hold a Mockner hearing on the IAC claim. That is almost exactly what Kathleen is saying in her petition. Okay, they're saying that Render found an expert that could directly contradict the state's expert. The circuit court in this case tried to say that they didn't find one side more reliable than the other. I think they actually said that they found the state's witness more credible. That is not for them to decide. Okay, that is something that a jury was supposed to decide. Okay, it's not for the judge to decide on the motion whether one is more credible than the other. They have to have a hearing for that. Okay, you can't just decide on paper and say like, no, so that's why the Court of Appeals was like, no, that's not your job. Your job was not to decide the credibility of these witnesses. Your job was to decide whether a hearing was warranted so that there could be an adversarial procedure in order to question both these witnesses. So when Kathleen is saying that they didn't present any opposing experts, and now she has these experts that are directly contradicting, what the state's witnesses said. I mean, if you're going strictly by what they're saying in Render, it's saying that since the new expert testimony was relevant and material to the case, the circuit court must hold a Mockner hearing on the IAC claim. So I guess the only question is whether the court would think it was relevant or material, but I don't know how they can't be. Especially when you're talking about like blood spatter and things like that, because I mean, the blood in the RAV was a huge thing for the state. That was a huge piece of evidence that they needed to overcome. And so having an expert say, yeah, we don't believe there's any way that he could have been actively bleeding and made these blood stains is kind of an important distinction. They also said in Render, it is a prerequisite to appellate review of an ineffective assistance claim that the challenged attorney explain his or her actions at a post-conviction evidentiary hearing. And that they're quoting State versus Mockner, which is why it's called a Mockner hearing, because this is where they established that you really need to evaluate an IAC claim at a hearing. You need to have these attorneys get on the stand and explain themselves before you can fully say whether they were deficient or not. They also say that the post-conviction court must hold a Mockner hearing if the defendant's motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. And that they're quoting State versus Allen. And if you remember in Kathleen's petition, she, especially in the motions for reconsideration, she really hit on Allen hard. That was with the 5 W's, and she even had a graphic describing it. And that's exactly what Render did. She satisfied the W's under Allen. And their ruling here, they're saying that they must hold a Machner hearing. If you're going to believe that these material facts that are being presenting, if you're saying that if they're true, if he should be entitled to relief, then you must have the hearing. And that is exactly the argument that Kathleen made, which is why I hope she's citing this case, because this is a recent ruling. Okay, so any recent rulings are always really good to a case. Okay, so one of the other similarities is that KZ said that trial defense counsel failed to thoroughly investigate other suspects and instead chose a scattergun approach of simply naming individuals without meeting the requirements of State versus Denny. And that's a little bit what I talked about a few minutes ago. Okay, they just took a bunch of names that Steve gave them with some background information and threw together a Denny motion without actually investigating. You cannot satisfy Denny if you don't investigate. How can you find a motive for somebody to have committed the crime if you don't investigate? It's impossible. It angers me. The failure of Steve's counsel to adequately review discovery material is important to the issues surrounding the Dassey computer as well. Despite the fact that KZ keeps saying, this is actually me, so I don't know why I'm reading it. Despite the fact that KZ keeps saying that it's a clear-cut Brady violation, which if you watch my other videos, you know is directly contradicted by case law, there is a really good possibility of winning that claim under IAC. And Thiel is another case that supports that. Because they're saying that you have to adequately review discovery material. And if you don't, it's deficient. In the state's response to Kathleen, when she filed the motion to supplement the petition, when she was talking about the CD, the state argued that the alleged Brady violation was instead a complete failure on trial counsel's part by not fully examining discovery materials that were provided to them. And when I first read this, because everybody knew that prior to this, I was screaming like, why is it not filing this as an IAC claim? Why is it only under Brady? Why is it not an IAC claim? When I first read that, I almost started laughing because I was like, thank you. Even they're making the case for saying that this is an IAC claim. This is all trial counsel's fault. It's not their fault. And I was like, that's a strange approach. They're essentially agreeing that this is more of an IAC claim. So in order to mitigate any chance of them handing her an IAC claim on a silver platter, they had to try to explain why it still wasn't IAC. So what the state said was that the defense team made the strategic decision to focus on the blood planting defense, making the Dassey computer irrelevant. Okay, so what's important about that is that one of the biggest defenses to an IAC claim that a state will argue, or the opposing counsel will argue, is the trial strategy excuse. Trial counsel is not ineffective if they simply made a strategic decision and it ended up not working out in their favor. That's why the state made sure to add this to their argument. The judge essentially said the exact same thing. She said too, this is more of a failure on trial counsel's part, but it was a strategic part on their, it was a strategic decision on their part, so therefore it wouldn't amount to IAC. Nice try. This is an area where Thiel is again helpful, okay? Because in their ruling in Thiel, the Supreme Court says, we first recognize that counsel's failure to review certain portions of the discovery provided by the prosecution was deficient performance as a matter of law. In a felony case where the client potentially faces significant prison time, it falls below objective standards of reasonableness to fail to read all portions of discovery that may have the potential to adduce information that is either beneficial or damaging to the client's cause. We can perceive no strategic or tactical advantage for a criminal defense attorney not to read discovery provided by the prosecution that may yield exculpatory results. or exculpatory evidence. Then they go on to say the discovery documents in this case could have contained, and in this case did contain, information that would have benefited Thiel's defense. Unread discovery not only provided critical information directly, but also provided insight into other facets of the case that deserved more thorough inspection or investigation. So this contradicts what the state is trying to argue in Steve's case. The state is trying to say that trial counsel didn't examine the computer because it wasn't part of their trial strategy. But the Supreme Court says here that they can perceive no strategic reason for a criminal defense attorney not to examine discovery by the prosecution that may yield exculpatory results. And it actually makes a lot of sense when you think about it, because how can you make a strategic decision about something you haven't actually looked at? They could never have said that we aren't going to use the computer as a strategic decision when they had no idea what was on it. They had no idea what they were going to find. You can't make a strategic decision about the unknown. The state also couldn't have argued that the DCI report's listing of the contents of the CD made trial counsel decide not to pursue it any further in fear that it may end up looking worse for the client, because in the above passage, I also said that, or the Supreme Court also said in the above passage, that it falls below objective standards of reasonableness to fail to read all portions of discovery that may have the potential to adduce information that is either beneficial or damaging to the client's cause. Meaning that an attorney is ineffective for not examining discovery even if they think it could be damaging to their client. Okay, so they have to look at everything, mainly because, well, if there's something damaging to your client, you have to know about it so that you can prepare for it. You can't just pretend that, oh, maybe if it's not there, if I pretend it's not there, then maybe the state will never find it. It will never bring it up. So it is reasonable to conclude that Steve's trial counsel fell below an objective standard of reasonableness since they either missed or ignored the DCI report. They neglected to review the contents of the DVDs they were provided, and they failed to conduct their own forensic analysis of the computer. If they had examined the computer and decided not to use it, then it could be argued as part of trial strategy and it wouldn't fall under IAC. Okay, so now on to this is the Supreme Court's analysis of the duty to investigate claim. Okay, which to me is a huge part of this case, because it's one of those things that from the very beginning, from the time I read that Denny motion, it was like, why did they not investigate? And then when they got during the trial and during Bobby's testimony, when he mentioned the statement between him and Mike and Steve, the exchange, and trial counsel acted like they were blindsided by it, I sat there then when I was reading the transcripts and I was asking myself, why the hell did they not interview Bobby themselves? Why would they not interview him? Why would they not interview anybody in the family? It's a little bit harder sometimes to get access to witnesses that may not want to talk to you, but his own family? Why would you not interview them? Why were you relying only on police reports? It makes no sense. Anyway, on to their analysis of this. Under Strickland, counsel has a duty to make reasonable investigations or to make a reasonable decision that makes particular investigations unnecessary. Also, a defendant who alleges a failure to investigate on the part of his or her counsel must allege with specificity what the investigation would have revealed. And that is exactly what Kathleen has done. That's why she lists a long list of not only what the IAC claims are, but what would have been found if they had investigated and how it would have helped Steve's case. They say, if we decide that the decision not to investigate is unreasonable, we must find that trial counsel's performance is deficient. So they're just saying, if we decide that their decision not to investigate was unreasonable, then they have to be found as, their performance has to be found as deficient. You satisfy that first prong of Strickland. The Supreme Court notes that the credibility of the complaining witness was paramount to this case. In this situation, trial counsel was aware of the need to locate any evidence or information to impeach the complainant's testimony regardless of what was found in discovery. And again, it's important for them to say regardless of what was found in discovery, because they're saying that even if it wasn't discovery, it was your job to try to find a way to impeach this witness because you knew she was the star witness against him. Again, sound familiar at all? I really don't have to spell this out for you, do I? In addition, a more thorough interview with Ekern might have revealed that Joanne first told Ekern about her sexual relationship with Thiel only a short time before she reported it to police. This might have prevented Ekern from testifying to Joanne's prior consistent statements or made it easier to expose some inconsistencies in his trial testimony. The police report indicated that Joanne informed Ekern about the alleged sexual relationship in a telephone call. Counsel did not take any cue from this reference to a critical telephone call. In Steve's case, were there any critical telephone calls that you think might have really helped Steve's case that they maybe could have subpoenaed the records for? Just, show of hands. Anyone? Can anyone think of one? I don't know, maybe Colburn's telephone call? Since they specifically knew he used his cell phone to call dispatch and they did not have a specific date of that phone call, and they spent a lot of time during Colburn's testimony, like when they were cross-examining him, trying to say, well, we think you made the call at this time. We think you made it on this day, didn't you? And he kept saying, no, I didn't. No, I didn't. Well, if you would have subpoenaed his cell phone records to find out when that call was actually made, you could have destroyed him on the stand. You would have known if he was lying and you could have destroyed him. Bottom line. It seems so easy, doesn't it? And so again, with this, they said Thiel's counsel failed to pin down the date that Joanne told Ekern the whole story of the alleged assaults. In addition, greater investigation on this point might have unearthed damaging phone records that could have been used to impeach Ekern's testimony at trial. And it's not just the Colburn phone call. They also could have used phone records to hammer away at Ryan Hilligus to find out why he made 22 phone calls to an unknown number prior to finding out that, on the day that Teresa went missing. That would have been important, very important. So again, the Supreme Court here is saying that those were critical phone calls, and you should have made the effort to try to investigate. And then you add into it the nuisance call that Tom Pierce testified about. It would also have been really good to know where those phone calls were potentially coming from, because if they could have found out that there was somebody else that wasn't Steve that was calling Teresa, and she was being harassed by this person or felt like this person was bothering her. Again, Denny, that would be a perfect Denny suspect. Sorry, I'm just reading the comments here. Carol's asking, he said, didn't he receive 22 phone calls? I thought he made the 22 phone calls, or maybe they were just back and forth, but I thought that he was the one that made the phone calls. But correct me if I'm wrong. It's been a while since I've read that detail. Okay, so let's see. They go on to say that the failure to undertake any independent investigation was deficient. It shows how counsel lacked initiative to develop Thiel's case and instead assumed a more reactive role to the development of the evidence. And that's exactly what Steve's counsel did. When they say they took a reactive role, that means they were looking at the police reports, whatever, and they were reacting to that instead of going out and trying to find something that helped them. They were just trying to combat what they were being told instead of trying to find something on their own. It says the court also agreed with the circuit court's evaluation that trial counsel was deficient for failing to file a motion that would have allowed the defense to offer evidence of the victim's prior personal and medical history. Not probably that relevant to Steve's case. I'm sure I could make a similarity comparison if I wanted to, but and they also mentioned how failure to examine discovery and failure to investigate can sometimes be intertwined. And this is the example they give. Defense counsel cannot claim to have decided, okay, this is important because it's exactly what I said before. Defense counsel cannot claim to have decided strategically to forego interviewing a particular witness if counsel has not read the police report relating to that witness, because that would not be an informed decision. Therefore, if we find that counsel's decision not to fully investigate was the result of not reading discovery, then the decision not to investigate is itself deficient. And it's just what I was saying about the computer before. It's like they can't make a strategic decision to use something that they haven't evaluated themselves or they haven't looked at themselves because it's not an informed decision. You can't say it's strategic when it's not informed. And the court is saying that even if they say that was a strategic decision, then it's still deficient, because how can you say it was a strategic decision when you actually didn't look at it? So either way, it's deficient. They were deficient in their performance. And they're saying that it's not a reasonable excuse. Okay, so then we come to okay, I'm trying to stick with what I'm talking about right here now, guys. I'm just looking at the comments and they're kind of all over the place. Okay, so now I'm gonna move on to the prejudice prong. Okay, and again, this is very important to what the arguments that Kathleen is making. It says that prior to this case, the Wisconsin Supreme Court had never specifically addressed the issue of how to calculate prejudice arising from multiple deficiencies by trial counsel. And they said that several circuits had ruled on it, but they were going to, let's see, let me just read this real quick. Okay, they said that several circuits of the United States Court of Appeals had addressed appropriateness of looking at the cumulative effect of multiple instances of deficient performance. The consensus appears to hold that when a court finds numerous deficiencies in a counsel's performance, it need not rely on the prejudicial effect of a single deficiency. If taken together, the deficiencies establish cumulative prejudice. And this is something, and so then in the Seventh Circuit decision, Washington versus Smith, the Seventh Circuit said, evaluated individually, these errors may or may not have been prejudicial to Washington, but we must assess the totality of the omitted evidence under Strickland, rather than the individual errors. And they also make an important distinction when it comes to ineffective assistance of counsel. They said that the fundamental purpose of the Sixth Amendment's guarantee of effective assistance of counsel is not to assess the overall performance of counsel, but to ensure that the adversarial process functions fairly and reliably. And the U.S. Supreme Court said this in U.S. versus Chronic. The right to the effective assistance of counsel is recognized not for its own sake, but because of the effect it has on the ability of the accused to receive a fair trial. So what they're saying there is they're saying that, like, okay, you don't have to have an attorney like Len Kaczynski to have ineffective assistance of counsel. Okay, you don't have to be that monumentally horrible. Okay, you can have counsel that can be, on its face, somewhat decent in the representation, but all it can take is like one instance of them being deficient, you know, in order for them to, again, undermine confidence in the outcome. So they're saying that we're not trying to really assess the performance of counsel as a whole. We're trying to assess their performance with regards to whether it amounted to their client getting a fair trial. And that's why they're saying that multiple deficiencies must be evaluated cumulatively in order to give them proper evaluation as to whether that those errors prejudice the jury. And it says that the inquiry directs analysis of the issue of prejudice to the effect of the deficient performance on the overall reliability of the trial. And that's a very different, like, evaluation than just saying it's an overall assessment of an attorney's performance. That's not what they're saying. We are not evaluating an attorney's performance. They are evaluating the deficient performance and its effect on the reliability of the trial and whether the trial was fair. Okay, so in closing, the court held that while none of these deficiencies standing alone would have caused prejudice sufficient to undermine our confidence in the outcome of the trial, given the totality of the circumstances at trial, we find that the cumulative effect of these failures undermines our confidence in the outcome of the trial. We are sufficiently persuaded that the reliability of this proceeding is suspect, and that but for the numerous unreasonable errors of Thiel's counsel, there is reasonable probability that the result would have been different. And that is exactly what we hope they're going to say in Steve's case, that maybe individually these claims may not amount to prejudice, but when you look at them as a whole, altogether, the numerous errors, does that mean that those errors resulted in what was fundamentally an unfair trial? Okay, so that's all I have for my notes. Okay, so on to the questions. Are there more questions? Yeah, I don't, yeah. Yeah, thanks, Eric. Yeah, it's true. I try to really, I have discussed the case plenty in other groups over the years, but I really kind of just shifted my focus primarily to just discussing the legal issues. And I try not to discuss too much of the specifics anymore. They know, that's why I say in this group all the time, I say, like, stick to the legal issues, not the general facts of the case. Not that I don't think they're interesting, but it's just there are plenty of groups that do that. Every other group does that, except for this one. So, you know, when you want to discuss suspects and discuss certain things, then I don't really, I'm not a big fan of theories. I'm really not. All I've ever really said about alternate suspects is that everybody is innocent until proven guilty, as it should be. And anybody who supports somebody who's wrongfully convicted should feel the same way. So you feel the IAC case is good. Yes, IAC cases are very hard to win because of the prejudice prong. But I think that that enough has been shown that, you know, especially with regard to the computer. I mean, the computer bothers me. I mean, it does as far as them not looking at it. They had the DCI report, okay? They knew of the existence of the CD. They didn't ask for it, okay? Or they should have known. I shouldn't say they knew. They should have known, because either way, they either ignored the DCI report or they just missed it, and neither is acceptable. It isn't. They had the DVDs that had all the information, that had the actual image of the drive on it. And their excuse was, well, we didn't have the proper program to open it. What? Then get it. Or, I don't know, ask the state, can we use any of your facilities to read these things? You just can't ignore them. You should never be ignoring anything in a case. You have to look at everything. Oh, and what I was going to say before about the importance with Thiel, that he had exercised his right to a speedy trial, and his attorney had said, like, we could use more time. In that case, the court actually ruled, because the state tried to say, well, his attorney said they needed more time, and that, you know, so the reason they weren't properly prepared and they hadn't read all the discovery was because they didn't have enough time, because their client wanted a speedy trial. And the Court of Appeals, I mean, the Supreme Court still rejected that idea. They said it's still the attorney's decision. It's still the attorney's job to be prepared. You know, and even if his client didn't want that, you know, that didn't matter, because, you know, it's still the attorney's job to be prepared one way or the other. So that wasn't even an acceptable excuse. So that's why one of the things that I know the state said, and I agree, is that if, you know, they're using the excuse that they were given, you know, how many thousands of pages of discovery. Well, if you didn't have time to get through it all, then you ask for a delay in the trial. You don't just go back later and say, well, we didn't have time to go through it all. It was too much. Well, so what? That's not an excuse. Then you ask for a delay. Because in this case, Steve never exercised his right to a speedy trial. You know, he was never like, no, I want this trial to happen now. No, it was their job to have fully read all the discovery, to know this case inside and out, and you know, before they went to trial on it. And there's no way around that. What is going on with the tweet about 7 days? Kathleen said in an article that she'd be filing a motion with regards to something that came up while she filed the other motion about the testing. So I'll leave it at that. What do you think of Steve's chances are getting an evidentiary hearing? I think they're good because I think they have to be. And like I said, this is why the issue of procedural bar is so important. Because if they rule that he should have brought all these issues up before, well, then he's not going to win. But I don't see that. I don't see them doing that. And the reason that there's any gray area at all is because one of Kathleen's arguments is that essentially a pro se litigant, especially an indigent pro se litigant, meaning someone who doesn't have money to hire experts and hire an attorney, should not be punished because they can't put forth a petition that is as good as what an actual appellate attorney can do. And that's what she's saying. She's like, Steve, you're basically punishing him here because he tried to advocate for himself, because he had no clue that Megan Murder was coming out, first off, and he had no clue that he'd end up, obtaining Kathleen Zellner as his counsel. So he should not be punished. That's not really the point of the courts, is to punish somebody for not being rich and not having representation. And, and you definitely shouldn't punish somebody for trying to advocate for themselves. And the problem is there's absolutely no case law that's ever said that that is a reason to pretty much overcome procedural bar. But that doesn't mean it won't happen. I think it's a good argument, personally. So yeah, I mean, I think that I've said from the beginning that this case warrants a hearing. It's not just the IAC claims, it's a lot of the other claims. I mean, like, how can they be properly evaluated when, you're only hearing, we're only hearing Kathleen's side of it, so we really need to get these people on a stand and get them questioned to get their responses to it, so we can find out really if these claims are meaningful or not. Because of course, I mean, Kathleen Steve's attorney, she's going to be making assertions and claims that are going to sound great for him. That doesn't mean that when it comes down to it, they're all going to be that strong or not, but you can't make that decision when you haven't fully evaluated the claims. And you can't fully evaluate them if they aren't fully, if they aren't further investigated, during a hearing. You guys are killing me with your question, or your chat here. So I think other questions. Hi, Wendy. Nice of you to join me. I'm almost done. I knew Eric was going to have something to say about that. Just again, to tell everybody that this is one of the only instances ever, maybe I'll do it more in the future, since this discussion was very heavy on the case law and some very specifics with regards to the petition and rulings of the court. I actually did put in the description, a link to my video notes, so that, I try to read slow, but I know my slow is still fast for a lot of people, and I know it's a lot to digest. So just, download the notes and read through it, if you want to refresh your memory on something. So that's why I included it this time. How long have I been on? Oh my God, have I been on that long? Wow. Okay, well, who filed his first IAC claim? Trying to think of, well, it would have been, gosh, I don't even know if his appellate counsel filed an IAC claim, because he basically made the same arguments that Buting and Strang did. They were attacking more the judge's decisions in the case than any claims like IAC or Brady. I will go back to the discussion about juries. I mean, if you're in my group, you saw that they were asking about whether it has any impact on a case if a juror comes back later and says they change their mind about how they felt about a case. Short answer in that case is no. But I had said that if it's proven that a juror committed misconduct, or if there was some kind of misconduct going on in the juror room, then you can file a claim of juror misconduct in your petition for post-conviction relief. Now, just having one juror say something isn't enough. You need corroboration, which means you need several jurors or some other evidence that there was juror misconduct. A really good example of that is I know a lot of people have followed the West Memphis 3 case. And in that case, one of the reasons they got the Alford plea is because they knew they were kind of screwed on juror misconduct, because the jurors were never supposed to know about, but they definitely were not supposed to discuss Jesse Miskelly's confession because it was not brought into Damien and Jason's trials. So that was supposed to be left off of any deliberations because technically the jury wasn't even supposed to know about it. But they found in the juror notes, and then they actually found on the whiteboard that something was crossed off that was being discussed, and they figured out that what they were discussed was Jesse Miskelly's confession. And one of the jurors said yes, that it was brought up, and they just crossed it out like, oh, we can't discuss that. The fact that it was even brought up, though, was juror misconduct. It's not something that they should have brought up. And since there was corroboration, there was actual proof that this was brought up in the deliberation room, they had a very good case for juror misconduct. And that was one of the things that led to the state actually offering an Alford plea. Now, in interesting side note, once one of my favorite movies of all time is 12 Angry Men. I love it. I watch it all the time. And it's funny to me that even as much as I love that case, those jurors participated in so much juror misconduct. It's not funny. Like if it was actually like, well, I don't want to spoil it. I don't know if anyone's planning on watching it, but the conclusion they ultimately came to, it wouldn't matter. But if they had, never mind. I won't say any more than that. But it's just funny that I love the movie, but it is riddled with juror misconduct, something that would be really not allowed in any juror room today. But what was said, okay, so I brought this up in another video. In Steve's case, they did try to bring a claim of juror misconduct, okay, against Carl Wardman, who was the man whose son was a Manitowoc County Sheriff's deputy. And everybody knows now that Rick Mahler was one of the jurors and that he deliberated for the first day, and then he had a family emergency and had to leave. And Rick testified during the appeal that Carl Wardman refused to deliberate. Refusal to deliberate is juror misconduct, if it can be proven. The problem, and the reason Steve lost on this claim was because since Rick left early, he wasn't there for the entire amount of deliberations. So even though he could say and testify to the fact that Carl Wardman did not deliberate on the first day, he could not testify to the fact that he never deliberated because he wasn't there the entire time. So Steve lost on that claim for that reason alone. If another juror would have come forward and corroborated Rick's story and said that, yeah, this guy never deliberated, then they might have had a case. I don't really know the stance of many of the jurors on Steve's case now, but just having a change of heart is not enough to overturn a conviction. There would actually have to be misconduct. One of the jurors I know had an open Facebook page, Diane Free, and she was what you'd expect from a lot of the people there. She was outraged by making a murderer. She felt sorry for the Hallbachs. She said that, we don't know the case. We weren't there. She heard everything. And if we'd heard what she heard during the trial, we would have known he was guilty too. And this guy was guilty of sin and blah, 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 blah. So no hope there. No, I mean, Carol was asking, is there existing procedure excluding people related to or employed by police court personnel? If they hadn't disclosed that fact, it could have been a problem, but they did. I mean, Buting and Strang knew who he was, and they knew that he had a son who was a Manitowoc County Sheriff. So, they disclosed it. So he disclosed it. So he did everything he was supposed to, and they still put him on the jury. So no, that's fine. If the council decides to put him on the jury, then there's nothing anyone can really say about it. That's not something that can really be second guessed. That's not something you can appeal and say, well, they shouldn't have put him on the jury. That you can't do that. Yes, Christy, you need to watch it. 12 Angry Men, obviously, there is the original version from the 50s with Henry Fonda. And then there was a remake with Jack Lemmon that was made in the 90s, I believe, and they're actually both really good. Watch either one you can find, or watch both even. I love that movie. I had an interest in law even way back then, so I've always been interested in it. But it's just an excellent movie. I've seen the play too, so. It's interesting. I read a story by Judge Sotomayor, who is one of the U.S. Supreme Court justices, and she said that 12 Angry Men is what actually made her want to be a lawyer. And that when she got to be a lawyer and then a judge, she said that she absolutely hated the fact that she knew, as much as she loved the movie, that she was like, oh my God, that was such juror misconduct. So she said the same thing that I kind of always thought when I watched it. And she said, I still love the movie, but she does these appearances where she talks about that. She's like, as much as you love the movie, don't think that's what you should be doing in a jury room. Yeah, Carol, like in a lot of cases, like a lawyer is not going to want to put some people in certain professions on a jury. That doesn't mean they can't. They just are smart and don't. Like no attorney would ever want me on a jury. If you're smart, like if you ask the right questions, you should never put me on a jury, because I'll be your worst like that. I will either be the person that you love or you're going to hate. Both sides are going to have an issue, because I won't believe any of the BS you're trying to sell me. If you're trying to like use smoke and mirrors to get a point across, I'm going to know it. So I'm not going to be fooled by either side that's trying to use anything other than the law to try to convict somebody. No, I wasn't alive then, but I watched it when I was young. No, I was not alive in the 50s, but I watched it when I was pretty young. Probably should go to law school. Okay, well, this has been super long. I don't know if it's because of the day or just because of the time. I know I didn't have a lot of people here, but I only had like 50 people last time, and then there were like 1,500 people that watched it within the next few days. So that's good. I know people are still watching it after the fact. So. What are the next steps after the brief is filed? After Kathleen files her brief, then the state has the opportunity to respond. And then they have 30 days, but they'll get an extension. And then Kathleen has 15 days after that to file a reply. And I know Kathleen said in an interview that then orals will be scheduled. But again, I've said it before that orals are not the norm in the Wisconsin State Court of Appeals. There's only been one criminal case in the last 2 years where they've scheduled oral arguments. So it could happen. It could, but it's far from a guarantee. They could decide the case on briefs. And honestly, they should be able to decide the case on briefs. They really should. Because I think it's such a clear-cut error. There's such clear-cut errors in the judge's decision that they shouldn't need to have a full-blown oral arguments on these issues. No, Kathleen has not filed anything new today. This is just, like I said, this is one of those things that I've had in the back of my mind for a while. I finally had time to sit down and put all my thoughts down on it. There's other cases there's other case law that I really want to talk about, because Thiel was a case that I knew like applied on several different levels to Steve's appeal. And there are so many similarities to some of the things that the court said, which are the arguments that Kathleen is making. So I think it's just a really important case that people should know about, should understand, and hopefully make you feel a little bit better about some of the arguments that she was making. And I just threw in Render there because the state versus Render, because of the whole competing expert witnesses testifying, and that the court has said that a hearing should have been allowed on that. So I think that's an important one for Steve's case as well. Hopefully she'll cite it. All right, then I'm going to wrap it up. I think I got all the questions for now, but as usual, you guys can add any more questions to the comments, and I will take a look at them later. All right, everybody have a good night. Bye.